Illinois just got hit with a ruling they didn't see coming, and the way they responded to it tells you everything you need to know about how scared they actually are right now. Here's the situation. There's a major federal lawsuit currently working its way through the Seventh Circuit Court of Appeals. It's challenging Illinois' sweeping ban on commonly owned semi-automatic rifles, think AR-15s, AKs, and their prohibition on magazines that hold more than 10 rounds. This law, known as PICA, is one of the most aggressive gun bans in the country, and it's currently hanging by a thread. But something just happened in a completely different court in Washington, D.C. that sent shockwaves straight into the Illinois case. And Illinois' reaction to it was immediate, aggressive, and honestly, very telling. Let me give you the full picture. Earlier in this case, a federal district court judge already ruled that Illinois' rifle and magazine ban violates the Second Amendment. He found that these firearms and magazines are commonly owned by millions of law-abiding Americans for lawful purposes, and therefore they are constitutionally protected. That was a massive win for gun owners, but Illinois kept enforcing the law while their appeal moved forward through the Seventh Circuit. The challengers then asked the Supreme Court to step in and stop enforcement while the appeal played out. The Supreme Court declined to intervene at that stage, but Justice Clarence Thomas made a pointed statement, essentially signaling that the High Court would eventually need to address whether states can ban the most commonly owned rifles and magazines in America. That pressure didn't go away, it just kept building. Then, the case was argued in front of the Seventh Circuit, and during those arguments, the federal government, under the current administration, sided with the challengers. The Trump DOJ stood up in that courtroom and argued that Illinois' ban conflicts with Bruin, and that firearms like AR-15s are protected arms under the Second Amendment. The judges also pushed back hard on Illinois' attempts to relitigate factual findings that had already been made by the lower court. That was already a tough spot for Illinois, but then something new dropped. A federal appeals court in Washington, D.C. issued a ruling in a separate case, known as Benson, striking down the district's ban on magazines holding more than 10 rounds. The court held that these magazines are protected arms under the Second Amendment. The reasoning was straightforward. These magazines are in common use by tens of millions of Americans for lawful self-defense purposes. They are functionally inseparable from the firearms they're designed to work with, and because of that, the constitutional burden shifts to the government to justify the ban using history and tradition from the founding era. The challengers in the Illinois case immediately brought the Benson ruling to the Seventh Circuit's attention, and that's when Illinois panicked.
Their response came fast, and it was aggressive. Illinois told the Seventh Circuit 3 things. First, ignore Benson entirely. They called it an outlier that conflicts with every other appellate court that's addressed the issue. Second, they attacked Benson's core legal reasoning, arguing that just because a magazine helps you operate a firearm doesn't automatically make it a protected arm under the Second Amendment. And third, they said Benson got the common use analysis completely wrong, that relying on how many people own something is circular logic, and that there are plenty of other appellate decisions that went the other way and upheld magazine bans. Now here's what you need to understand about that response. When a state scrambles this hard to discredit a single ruling from another court, a ruling that isn't even binding on the Seventh Circuit, it's not because they're confident, it's because they're scared. Illinois sees exactly what Benson does to their case. It hands the Seventh Circuit a clean, direct, and well-reasoned appellate ruling against magazine bans. It gives the judges another path, a legitimate legal road away from the earlier Bevis decision that Illinois has been leaning on heavily. And here's what makes it even worse for Illinois. Benson is still standing. The D.C. court denied the request for expedited rehearing. They also denied the motion to suspend the ruling while that process plays out. So Benson is active. It's good law. It can be cited. It has not been vacated, put on hold, or overturned. Illinois' fallback argument of just ignore it, it might not last, got a lot weaker the moment that rehearing was denied. So right now, here's where things stand. A lower court already ruled Illinois' ban unconstitutional. The federal government is backing the challengers in the Seventh Circuit. Justice Thomas has publicly signaled the Supreme Court is watching. And now there's a fresh appellate ruling from another circuit directly striking down the same type of magazine ban Illinois is trying to defend. Illinois is not in a strong position, and their aggressive attempt to contain the damage from Benson only confirms it. The Seventh Circuit now has everything it needs to rule. The question is which direction they go and whether they use Benson as part of the reasoning to strike down one of the most expansive gun bans in the country. If they do, the ripple effects don't stop at Illinois. States like California, New York, and others with similar bans on rifles and magazines would immediately feel the pressure. This one ruling could become the foundation for dismantling PICA-style laws across the entire country. The Seventh Circuit's decision is coming, and when it drops, we'll break down every detail of what it means for gun owners nationwide. Make sure you're subscribed so you don't miss that update, because this could be one of the most significant Second Amendment rulings in years.